Is it fair that a defendant with limited financial resources but posing a low risk of committing a crime are held in jail pending trial? Is it fair that defendants who pose significant risk to committing additional charges or may seek to obstruct justice through witness intimidation or retaliation are released because they have access to money and can be released on bail? Is it fair that the arbitrary factors of economic resources, not risk of flight, not dangerousness or failure to appear, will determine more often than not whether one is pretrial detained? Is it fair defendants who are presumed innocent can sometimes spend years in jail awaiting trial? We are here because we can and we know we can do better. We are here because these enhancements, these improvements to our system can make our community safer, our neighborhoods more secure, and they can also promote the civil liberties that we hold so dear. We are here because the recent events in various communities across our country suggest that there are several sectors of our community who believe that the system is unfair. We are here because we need to answer those critics with positive reforms to make our system more just. We are here because lives can be destroyed because they are sitting in jail for inordinate periods of time. We are here because the criminal justice system has been constantly focused on meeting its obligation to our communities and neighborhoods to have a safer community and a better system. America's exceptionalism and the continuous movement to make it a more just society, a safer society, needs your support. It needs your commitment, and I would suggest it needs to have champions like all of you in this room. There's some great work being done here, and I am proud to be part of it, ladies and gentlemen. Thank you.
So Judge Grant is the administrative director of the New Jersey court system, and what he was describing at the beginning of that video clip is the old system we had in New Jersey. We had a system where people were held in jail for long periods of time, not because of the risk that they wouldn't show up in court, not because of the danger they posed to the community, but because of how thick, or in most cases, how thin their wallet was. People at a certain point recognized that that was fundamentally unfair, and New Jersey decided to fundamentally transform its pretrial justice system. So things started when the Drug Policy Alliance put out a report, which we're going to talk about in a couple minutes, that documented who was in jail in New Jersey, why, and for how long. After reading the report, the public defender for the state of New Jersey, Joe Krokora, sent a letter, you see a copy of it here, to the Chief Justice of the New Jersey Supreme Court, imploring him to take a look at the structural issues that allowed these gross injustices to exist. The chief responded to the letter by forming what he called the Joint Committee on Criminal Justice. In setting up this committee, he brought together stakeholders from all parts of the criminal justice system. We're talking about judges, the attorney general, county prosecutors, the public defender, the ACLU, private attorneys, court administrators. These were people with really diverse opinions about how a system, a good pretrial justice system, should work. These are folks who are adverse to each other in court every day. That was the system we had in New Jersey. Along with these lovely amusements, we had a system where poor people were often held in jail, often on really low amounts of money bail. And any defense attorney knew, and frankly, any prosecutor and any judge knew the incredibly coercive impact that being held on monetary bail had on people. So people pled guilty to crimes, whether they were guilty or not, because they were offered a chance to go home. And that created huge injustices.
And the other thing that was sort of unique about our old system is that under our old system, judges were not allowed to consider dangerousness. The only consideration a judge could make in deciding somebody's bail was whether or not they were a flight risk. So in this new system, one thing that we had to acknowledge was that the dangerousness of an individual, or not the dangerousness, but whether or not they would commit a new crime on release, had to be a part of any new system. And under the old system, it was something that we weren't even allowed to talk about in court.
But just because we weren't allowed to talk about it didn't mean it wasn't a pervasive consideration. Obviously, judges were considering dangerousness. They just used risk of flight as kind of a subtext to talk about dangerousness.
Absolutely.
And so, as I alluded to earlier, the Drug Policy Alliance released this really powerful report, and it was a snapshot of a day in the life in the New Jersey jail system. And what we saw was that there was a huge pretrial jail population of, thousands and thousands of people. Most of the people who were in jail were being held as pretrial detainees. So these are presumptively innocent people being held in jail. You see on the slide here, 12% of people were being held on bails of $2,500 or less, right? So these aren't people who kidnapped the Lindbergh baby. The judge has already made a determination that this isn't the crime of the century, but these people are in jail simply by virtue of their poverty. And in fact, half of the people who were pretrial detainees in New Jersey were not charged with crimes of violence, sex crimes, or weapons offenses. So if you assume that those three categories are the kind of more serious buckets of offenses, half of the folks are in on different buckets. So whether it's a drug possession case or a petty theft case, those are the folks who are being jailed at great public cost. And they weren't in for brief periods of time. 314 days, this study found, was the average amount of time before resolution. But criminal defense practitioners knew how averages can be really misleading, right? Shaquille O'Neal and I average about 6'6", and that tells you very little about Shaquille O'Neal's height or my height. Bill Gates and I average a net worth of $30 billion, which again is not very illustrative of either of our pocketbooks. And so the same thing was true with the amount of time people spent in jail. Lots of people were getting out of jail in a day or two, which meant there were people at the other side to kind of shift the average. And so we were involved in a case where someone was in jail for 4 years and 3 months pre-trial, and neither of the appellate courts that looked at it thought that was a problem. The other kind of hallmark of the system was that because we couldn't talk about dangerousness, there was a real dishonesty to it. So when you had someone charged with a horrific murder who had lived in a community for his or her entire life, you had the judge talking about risk of flight. When we knew what was on the judge's mind was the person's risk to commit another offense. And we can't not comment on the fact that this disproportionately, of course, impacted poor people, but also, and the DPA study revealed this, impacted people of color. Black and brown people were more likely to be stuck in jail, and people stuck in jail were more likely to plead guilty, lose at trial, and get harsher sentences after trial or plea. So the effects were really pervasive. And obviously, people who were in jail, even for short periods of time, risked losing apartments, losing relationships with their children, custody, jobs. So the consequences were really dire.
And the studies that we were looking at during that time period that showed just 3 days of pretrial incarceration could have devastating consequences in people's lives well beyond those 3 days and up to a year, 2 years out because of the loss of jobs, the loss of contacts, the loss of opportunity. So all of those things were going on, were additional issues with the old system.
And we tried to litigate around it, right? The Office of the Public Defender, the ACLU, we tried to find litigation strategies to get us to a better system. So New Jersey had, after Barker v. Wingo, never adopted either a statutory or a regulatory scheme to say, here's how long a reasonable amount of time is to indict someone or bring them to trial. And instead they said, we're going to use a reasonableness test. And the problem with the reasonableness test, of course, is that when you had an appealing defendant, courts occasionally found that her speedy trial rights had been violated. And when you had an unappealing defendant, even one who had been in longer than the appealing defendant, courts found a way to find that delay reasonable.
And it was routine that people were sitting in jail 6 to 9 months before they were even indicted on an offense.
And in the county where Jen and I had been practicing, a year was the absolute minimum time someone would sit before a trial, and 2 years was a pretty frequent amount of time. And so, as I said, we took a case to the Supreme Court. We argued that the speedy trial rights needed to be either codified in statute or in court rule, and the Supreme Court didn't buy it. We litigated bail cases that talked about the role that dangerousness could have, and there was a case, I mean, it's worth talking about for a second, because there was a guy, and he had a kind of serious record, but the crime he kept committing was that he was going into his front yard naked and masturbating. And it was a low-level offense under the New Jersey Code, and the guidelines for the bail was that it wouldn't exceed $2,500. And he was posting that bail, showing up in court, and then going home and doing the same thing, getting rearrested. So at one point, he had 3 different cases pending before the same judge, and she kept seeing him on different days. He would show up in court, and at a certain point, she said, "Enough already. You're a menace. I think in order to protect the community, I'm going to set your bail at $250,000. And what she meant is, I'm protecting the community by ensuring that you can't make bail. And it went to our appellate courts, and our appellate court said, no, we're not allowed to do that. We can't consider dangerousness. So we're going to reduce the bail to $150,000. So litigation was not proving to be an effective way to either move the ball on bail or on speedy trial. And so stakeholders got together at the urging of the Chief Justice, as I've alluded to earlier, and you see some of the stakeholders there. And we got together for our first meeting. And in the first meeting, we were charged with the following. What are some ways we can tinker with the criminal justice system in terms of bail, pretrial release, and speedy trial to make it more fair? These are ways that weren't going to involve legislation, and they weren't going to involve a constitutional amendment. And this group met at a long table the first day, and this is a group that literally couldn't agree on what we were going to have for lunch. And in the first meeting, we were unanimous. There was no way to tinker with the system to make it more fair. The only way to make the system more fair was to fundamentally reimagine it, to transform it from a system that was obsessed with resources to one that was trying to measure and manage risk.
But one of the things that was required by the stakeholders coming together was there were some concessions that had to be made. And it's made by all of the parties coming into the room, because in order to reimagine the system, one of the important things was to make sure that everybody's constituents were represented and were getting what they needed from the reimagined system.
And in terms of concessions, the opening volley was served by Joe Krikora, by the public defender. And he wrote a letter to the Chief Justice and to the Attorney General and to all the members of the committee where he said, listen, we're a liberty-protecting organization. Our job is to get people out. However, I recognize that in limited, exceptional circumstances, there might be instances where people pose such a risk to public safety that detention would be appropriate. That concession, admittedly a big one, but that concession really got the ball rolling and allowed other people to make concessions. So then the Attorney General responded by saying, great, we agree. We want to be able to detain people in some situations, but we agree that it is a gross injustice to jail people because of their poverty. And the Attorney General it wasn't lip service, to his credit. I should say that when we pointed out to him, listen, Attorney General, this is going to mean you're going to get fewer guilty pleas, because when people don't have the get out of jail free ticket, they might not take those deals. And his response was, those aren't the guilty pleas we want anyway. So there were real concessions that were made on kind of how to envision the system. And I think that's what let us get to where we got. So in order to reimagine the system, after the Joint Committee put out recommendations, there was legislation that went through, and it was gross in the way legislation always is. It was a sausage-making process that no one really wanted to look too closely at. And again, there were more concessions, and I think no one would look at the New Jersey system and say, this is a perfect a model of legislation that protects liberty and does all the things we want the statute to do, but it represented the art of compromise. And then in order for the legislation to become effective, New Jersey voters had to authorize a constitutional amendment. As Jen indicated earlier, we had a constitutional provision that said, except in capital cases, and we didn't have capital cases, there shall be a right to bail. And so we had to change that if we wanted this legislation to go through. And New Jersey voters in November of 2014 voted by a margin of something like 60-40 that they approved this constitutional amendment. And so what the statute does is it says we're not going to just look at bail and pretrial release to try and make sure people show up in court, though that remains one of the principal purposes, but we're also going to try and ensure that the defendant won't pose an undue danger to the community. Obviously, there's always a risk that someone will pose a danger to the community. The bill looks at kind of elevated risks. The statute looks at elevated risks. Another thing judges may consider, though admittedly it kind of is relegated to the third tier, is whether or not the defendant will obstruct justice. Okay, so I think the key to thinking about this system is the point that I just made, which is we can't have a system that says we are going to let out the people that don't pose a risk and keep in the people who do pose a risk. Because frankly, that would mean jailing far too many people, either practically or constitutionally. It just wouldn't be permissible to jail anyone who posed any risk whatsoever. So the question in our system is, how do we measure risk first? And second, how can we effectively manage it? And in the rare case where we can't manage it without jailing someone, jail might be permissible. Okay, so this is kind of New Jersey Law 101. When a police officer sees someone commit a crime or has probable cause to believe someone has committed a crime, they have two choices in New Jersey. They can issue a warrant or a summons. A summons is show up in court on such and such date. Under the old system, no money bail would have been set. Under the new system, no non-monetary conditions will be set. We'll talk about that more in a minute. And a warrant, of course, kind of triggers a more robust system. So one thing we've seen under this system is that there are more summonses being issued and fewer warrants, and we'll talk more about that in a minute. We're going to now talk about the group of people for whom warrants are issued. They're what we call in New Jersey eligible defendants. So if you're an eligible defendant, the first thing that's going to happen is you are going to go to jail, basically. And in jail, you're going to have a risk assessment conducted, and you're going to have a first appearance. And that, by statute, will happen within 48 hours. We've learned that a big percentage, I think the percentage is 80% of people are having those risk assessments conducted, and the first appearance is happening within 24 hours.
And that was by design for Judge Grant, who's the Chief Administrative Officer of the court, was pushing that these be done, even though the statute gives 48 hours, that they be done within 24.
And so New Jersey uses a risk assessment instrument, which we'll talk about in more depth in a minute. But what the risk assessment instrument is going to set up 3 different metrics of risk. What is the risk that you will fail to appear in court? That's FTA. What is the risk that you will be arrested for new criminal activity? NCA. And what is the risk you'll be arrested for new violent criminal activity? Because, of course, we care more if someone is going to commit a murder than we do if they're going to go commit a jaywalking. So step 1 in this process is you get these scores, and the judge looks at them. If, however, one of 2 conditions is present, a particular recommendation is going to be made to the judge. So if you're charged with escape, murder, aggravated sexual assault, first-degree robbery or carjacking, or certain gun possession offenses, the recommendation is going to be detention, no matter what. But that's just a recommendation, as we'll talk about. Part 2 is if you have this flag indicating elevated risk of new violent criminal activity and the offense that you're charged with is violent, you are going to get a recommendation of detention. Now, we're going to talk in a different webinar in much more depth about how the risk assessment works and what the process is for litigating this stuff. We're trying to keep it a little bigger picture here. Once you assuming you haven't been charged with one of those kind of elevated offenses and you don't have the flag and the current violent offense, then your risk assessment score is going to place you somewhere on this metrics. And if you're in the top left in the dark green, the recommendation is going to be releasing your own recognizance. And if you're in the bottom right in the dark red, the recommendation is going to be detention. And in between, there are going to be various levels of supervision that are going to be recommended to the judge. Now, regardless of what the recommendation is, if you're going to be detained, several things have to happen. The first is the prosecutor needs to move for detention. The judge cannot do it on her own. Second, the safeguards start with presumptions. And while New Jersey has a very broad applicability of detention, which is to say very few people are categorically excluded from being able to be detained, New Jersey's presumptions are, on the other hand, quite narrow. So there is a presumption of detention for people charged with murder or any crime that carries life. For everybody else, so including people charged with aggravated sexual assault, people charged with robbery, people charged with kidnapping, carjacking, attempted murder, the presumption is release. So we start from a place where our Constitution should place us, which is we assume that liberty is the norm and detention prior to trial the carefully limited exception. So the first is we have good presumptions. The next is there's an absolute right to counsel. There's a right to counsel at that first appearance where we're setting conditions of release, and at a detention hearing, there's also a right to counsel. There is robust discovery provided before a detention hearing. The state must turn over prior to the detention hearing any statements or reports that are related to the bases on which they seek detention. So if they say we have an identification of the defendant saying he was at the scene of the murder, they must turn over the statements and reports related to that identification. That it must be turned over, and all exculpatory information must also be turned over prior to the detention hearing. Defendants have a right to call witnesses. We are in the midst of litigating what exactly that means, which is to say everyone agrees that defendants can call alibi witnesses, that they could call character witnesses. The open question right now is whether the defendant can call an adverse witness. Can they call a police officer? Can they call a putative crime victim for the opportunity essentially to cross-examine that witness? And there is also in the statute a right to cross-examine any witness that the state presents. This is something where we've lost in litigation in the last year. In a case called State versus Ahmad Ingram, the state decided that they were going to proceed by proffer. Rather than calling a witness to make their proofs of probable cause and so forth, they were going to simply introduce an affidavit of probable cause. And the court said that that was okay. And there's one more safeguard that's not on here, which is really critical, which is what is the standard? What needs to be proven by the state in order to get someone detained? We know there's a presumption of release, and the question is, how do they overcome it? They need to prove two things by clear and convincing evidence. Well, they need to first prove that they have probable cause. Frankly, that's not a very high hurdle. But the more difficult thing for them to prove is they must prove by clear and convincing evidence that no condition or set of conditions will adequately serve the purposes of the statute, protecting the public, ensuring presence, and preventing obstruction of justice. So if there is an alternative short of jailing out there, then the court must impose that rather than detaining the client. Okay. This is a big change from the system that Judge Grant talked about in the beginning to the one that I just described. And so to get there, we had to do, we meaning stakeholders writ large, a lot of training. The judiciary had to do a lot of training to tell judges, listen, the way you've been doing it for your entire career is going out the window. We are no longer going to rely on money as the primary basis to ensure someone's presence. We're going to totally transform that. Prosecutors, too, had to totally accept a culture change, and it took huge training from the Attorney General and the county prosecutors. And defense attorneys are no less creatures of habit than the other institutional players, and it took a lot of work that Jen's going to talk about.
So training our lawyers for this, there was a lot that went into that. And one of the things that we found early on is we sort of expected as we started training lawyers that everybody would be on board with this new system. But we found that there were many lawyers who either because they had been doing it one way for a really long time, or even just because they were opposed to this idea that somebody could be detained without bail, that the first thing we had to do was just sort of do our own, we called it a roadshow, but do our own roadshow to convince our colleagues in the defense bar that this new system was the way to go, and this new system was going to be fundamentally better for our clients than the old system we were working under. So we called it sort of a three-part hearts and minds approach, where the first training that we did was just to convince people, like we tried to do with everybody else, that this system was far superior to what we were working under. Once we did that, then we started teaching people about the new law, the ins and outs of the statutes, teaching them about bail decisions from across the country so that they had some, because there would be no law. On day one, when they walked into a courtroom, there would be no New Jersey law that they could argue from because this was a brand new statute. So we gave them law from other jurisdictions that might be helpful. And then we started to train them on how to do a detention hearing, how to be effective at a detention hearing. And we anticipated legal issues that may come up, like the calling of witnesses, like the discovery issues. And we tried to say these are going to be the positions we're going to want to advance to make sure that all of our defense attorneys were going into court and saying the same things and making the same arguments so that when issues came up on appeal, we had a really good record below. Also in New Jersey, it's a little bit different in that we are not in charge of the lawyers who are representing people in municipal court. Our office, we only represent people charged with felonies, and we don't have misdemeanors in New Jersey. But we did actually do training for municipal court lawyers who may find themselves, because of certain domestic violence offenses are included as eligible offenses under the statute. We did training for them. And this was an audience of lawyers that we had never trained before. We were doing training for them. We also made sure that we continued to train people after January 1st, 2017. I think that has made one of the differences, is that once we figured out who was going to be doing these detention hearings on a day-to-day basis in all of our jurisdictions, we make sure that they would come together every couple of months to share ideas, to find out what was happening, to share motions that they may have filed. A motion that may have been successful in Camden County, which is on one end of New Jersey, might be able to be used in Hudson County. And really, in our statewide system, keeping our lawyers together as sort of a united front to advocate for our clients under the new system and to get the law and the court practices to be what we wanted them to be.
And I think one thing that's really important about what Jen said about trying to convince defense lawyers is she never said we went around trying to convince skeptical defense lawyers that this system was perfect. What we went around convincing them was that the old system was a civil rights disaster, that the old system was harming our clients, and that this new system, imperfect though it may be, had the opportunity to be better, and especially if we put our backs into it and we litigated every case to the fullest and trained everyone. So they were really fully advocating and recognizing just how important that pretrial decision making was going to be for our entire case, right? That the greatest predictor of success in the ultimate outcome of your case was going to be what happened in that bail hearing.
And there is one more thing I wanted to add is we also worked with the NACDL and the ACLU in creating, and you can see a picture of it here, the New Jersey Pretrial Justice Manual. This manual became, on January 1st, 2017, the only, as far as I know, guide to how to walk into court on day one, meet with your client, get the information you needed, do a first appearance, and do a detention hearing. And the beauty of this is that we made it available, and we thank NACDL for putting this together with us and the ACLU. And what this allowed us to do was have a manual not only for our own lawyers, but we made the decision to give this away to anyone. So prosecutors had it, judges had it. So the defense bar and the civil rights bar sort of became the people who wrote the book, so to speak, on pretrial justice reform on day one. And this is a guide that is still being used by many of our lawyers, and I think lawyers on both sides of the aisle today.
I mean, let me just quickly tell a story, which is, and we're going to talk later about this case, but the bail industry has filed suit against bail reform in New Jersey. And they sought a preliminary injunction in the federal district court, and the judge rejected their position in a 93-page opinion. But in that opinion, as he wanted to walk the reader of the opinion through how the New Jersey system worked, he cited to this manual. So it is, I think our decision to make it available to stakeholders outside of the defense bar has proven very valuable.
Oh, so we've also done continued work after the passage, after the enactment of all of these changes, and working together with the Attorney General's office, with the courts, with the ACLU, with the stakeholders to ensure that that all of this new reform continues to be implemented properly. One of the things that we do is each group meets with Judge Grant and his team once a month to check in on how is it going. What are the challenges for the defense bar? What are the challenges for the prosecutors? How can we tinker with and continue to make the system better and more effective for everyone? There has been aggressive litigation of any issue that has been unresolved by statute or by court rule. There is a rules committee that continues to write rules where there are gaps in the statute. We developed a pretrial justice committee. Our public defender, Joseph Kokora, is on. There's a number of key stakeholders that are on that are working with pretrial services. And we've had open communication between the stakeholders. And we're going to talk a little bit later about the fact that just because everybody wants the same system doesn't mean that we haven't had fights, both in the courtroom and in these committees and out of the courtroom. But because all of the stakeholders fundamentally believe that this system is far superior to the last one, the communication remains open so that all the parties can work together to continue to make the system better. But so one of the things that we've become sort of aware of, and I know Alex has spoken with people in many states, and I've spoken with people, and both of us talk to the press a lot about pretrial justice reform, and we recognize that we in New Jersey are unique. And that's not because we are the proud home to the Jersey Shore. Proud,
loosely defined.
As proud as the Jersey Shore. It's not because we are the proud owners of home state of Bon Jovi. Not so, I don't know, the jury's out on this one. And we are the proud home to Alex's favorite recording artist, Bruce Springsteen. But one of the things that makes New Jersey really unique in all of this was the way the stakeholders came together and the political courage that they showed in enacting these reforms.
And so we've talked about it a little bit. The defense bar was willing to give a little bit, at least on the theoretical possibility of detention, as was the civil rights bar. The prosecutors and attorney general were willing to acknowledge that they needed to get people out of jail who are there simply because of their poverty. And judges were willing to take a leap because it's always hard to be the first state of 50 to do something. And other states have tinkered with bail reform. I'm not suggesting New Jersey is the only state to do it, but the kind of broad statewide legislative reform really put New Jersey on its own path. And I think there are certain structural elements that made this possible in New Jersey.
But not everybody was always on board.
That is certainly true, right? There was opposition from the criminal defense bar. There was opposition from some members of the criminal defense bar. Obviously, there was a split there. From members of the civil rights community, again, a split there. The coalition that the Drug Policy Alliance really spearheaded, that included the NAACP and the Latino Action Network and other groups. There were also civil rights advocates who didn't like this system. And there were law enforcement that doesn't like this. There is certainly the most vocal opponents have been the bail bond industry, and we'll talk about that in a minute. But here's why I think New Jersey was uniquely situated for this. The right to counsel at every stage here, and I should say, I didn't, in my little safeguards slide, we didn't talk about the right to appeal, but there's an automatic right, there's an appeal as of right from any detention decision. If you are detained, you can appeal it to the appellate division, and it's an expedited hearing. Now, no one ever doubted that defendants would have a right at each of those stages to be represented by counsel. We also have a statewide public defender, so that's very helpful. Our Chief Justice and our Attorney General are both uniquely powerful in our state. The Chief Justice is both the head of the Supreme Court and the head administrator of the courts. He's also not elected. It's hard to understate how important it is. And that's not to diminish the political courage it took for Chief Justice Radner to take the lead on this. He was actually up for reappointment, which happens once in a judge's career, and still spearheaded this. But not being elected is certainly helpful. The Attorney General is the chief law enforcement officer in our state and has a supervisory role over the county prosecutors and the local police departments. So ultimately what the Attorney General says on the law enforcement side goes in New Jersey, and I know that's not the case everywhere. And impacted communities wanted this reform. Again, not because they thought it was going to be perfect, but because they recognized what an abject failure the previous system had been.
And we also had this sort of commitment from the judiciary to begin work before the law actually took effect. And I think that was one of the structural conditions that made the actual, day one, January 1st, 2017 forward more successful. About a year before the reforms went into effect, we started looking at cases that were older, making sure that people who had low money bails, we were reviewing those bails and getting people out of jail before then, so that when we started on January 1st, we had already reduced the jail population slightly and made sure that we were paying attention to those cases that had been lingering in the system for too long so that they wouldn't suffer as a result of the new system. So we talked about adversaries before. This one is my personal favorite, but the bail bonds industry particularly, as well as some of the other groups that Alex has talked about, were opponents of this law before it took effect, and some continue to be to this day. As Alex mentioned, some of the criminal defense and civil rights organizations were at first resistant because this idea of detention without the possibility of bail seemed counter to the liberty interests that we're also trying to protect. Local police departments have and continue to oppose the new law. We've also had this issue of one incident may happen where somebody gets out on pretrial release, commits a new offense, commits a high-profile offense, and everybody's knee-jerk reaction is, let's blame bail reform.
And we knew that was going to happen. No one, when we're talking about this reform in 2014 and looking ahead to 2017, no one said, we're going to make it through 2017 and the years that follow thereafter without anyone committing a new crime on pretrial release. But we also acknowledged that was happening under the old system. But we knew that our first big challenge was going to come the first time someone on pretrial release killed someone, because we knew it was going to happen, as it happened under the old system and as it'll happen under any system that doesn't simply jail everyone pretrial. And the question was, how are we going to respond to an incident like that?
And Alex alluded to earlier the bail industry. So not only has the bail industry filed lawsuits, some that the ACLU is involved in, but also has really come out publicly against this, doing interviews and talking about some of these incidents that we just talked about, where somebody gets out and commits a new offense. And this has kind of put us in the unique position, I think, sometimes of having to battle it out with members of the bail industry in the media, and I'm going to give you an example of that now.
Guys, joining us now is Alex Shalom from the New Jersey American Civil Liberties Union. Alex, welcome to Chasing News.
Thanks, nice to be here.
So, Alex, you've heard all about this bill and the objections to it, violent offenders on the street, crimes being committed, and at least in one case, an allegation that this bill has caused the death of a young man. What do you say?
I think it's a really reckless position to take. It's a position that ignores the reality of the old system we had. Under the old system, people got arrested, they posted money bail, and sometimes they committed new crime. That happened all the time under the old system. The only difference between this system and that system in terms of public safety is now people like Jules Black can be detained without bail. So Mr. Black is currently detained, a result that wasn't even possible last December. And so let's not pretend that the old system was a fair one. The old system was one that protected public safety. What we need to remember about the old system is there were 1,500 people in jail in New Jersey because they couldn't post $2,500. That's a system that failed individuals, it failed public safety, but it did profit bail bonds people rich.
Our brother here from the ACLU is obviously not a bail bondsman, because if he would have called any bail bondsman in New Jersey, we'd have looked up his record. And because he had 28 arrests, 28 priors, a lot of them with drugs and guns, we would have said, who's co-signing for you? Your mother, your dad, your uncle, your brother. We would check with the neighbors, and we would have made sure that bond was secure. If you are caught owning, possessing, or someone tells us you got a gun, we will come revoke that bond and put you back in jail.
Do you think, Alex, maybe there's a point that's not being discussed, that there is a responsibility when you involve a bail bondsman to actually hold someone accountable? Somebody has a stake in this guy showing up?
The truth, we're not talking just about showing up, though. Let's be clear, we're talking about not committing a new crime. And here's the problem with my friend Mr. Dogg's position here. He says, if he had known this guy never would have posted bail. I guess the question is, what happened the last 27 times with Mr. Black?
I've known Jen for a decade or so, and I think she's been waiting for the entire decade to get the opportunity to play that clip of me debating Dog the Bounty Hunter.
I do watch it a lot.
So, as Jen said, we agree with the prosecutors in our state that a system that looks the way our one currently does is better than the old system. That doesn't mean we don't fight. And so the New Jersey Supreme Court is scheduled to hear in March its 7th case on a pretrial justice issue. In every single one of them, the ACLU and the Office of the Public Defender have been adverse to the Attorney General and the county prosecutors, because we believe that the presumption should be liberty. And so in each case, we're saying this is someone who shouldn't be detained, or this is discovery that the person is entitled to, or this is process that the person must have before detention can be imposed. And they're arguing the opposite. And so we fought about discovery. We fought about what role does this risk assessment play? And it's really a critical question, because I will tell you, I'm in the camp of people who's really creeped out by risk assessments. I think there are real possibilities to use them in ways that are more effective than the old system, but there's something fundamentally that scares me about using an algorithm that relies on criminal justice data that we know to be flawed, that we know to be racist, that we know to be biased, and to use that to reproduce decisions. That scares me. But that's something that we get to now fight about in the courts. When judges were simply jacking up certain people's bails, they were relying on the same flawed data in a totally opaque way. Now at least the decision-making process is more transparent, and it gives advocates the right to fight over it. Cross-examine, all the things. What do these hearings look like? How robust must the process be? Is something we disagree with the other stakeholders on, but it hasn't changed our fundamental belief that this system is better than the one it replaced. So we had no idea on January 1, 2017, whether or to what extent this was going to work. But we felt like the mass incarceration crisis that was facing our country and our state was a crisis. And when in crisis mode, you sometimes have to take chances. And that's why we engaged in this endeavor. But to our, I won't say surprise, because we certainly expected it to work, but much to our pleasure, it's working pretty well. So here's what we've seen in the first year. We've seen newspapers reporting on this in a really positive way. So we're talking about, national newspapers like the New York Times. We're talking about groups like Pretrial Justice Institute, and they gave New Jersey an A in its pretrial justice system. I think there are reasons why New Jersey maybe that grade reflects some grade inflation, or a curve that I don't think is totally fair. But certainly people who are looking at bail systems have been happy with New Jersey. International looks at the United States have focused on New Jersey. And remember, the U.S. is pretty unique in its use of commercial money bail. It's the United States and the Philippines that use private entities to secure people's freedom in the pretrial system. And Jen told you about that we were all afraid, and we knew a case would come where something horrible happened. And sure enough, it did last month. And it was horrible. Someone twice released on pretrial release went and killed his ex-girlfriend. And after the prosecutor had moved for detention and had been denied. And the question was, obviously this was a tragedy, there was no debate about that, but how would it shape the narrative about bail reform and the role that bail reform had played in this woman's horrible death? And the Star-Ledger, which is the biggest newspaper in New Jersey, editorialized, and their point was very clear, which is, let's not blame the system for this failure. And both Jen and I got calls from editorial boards and newspaper reporters after that incident, and the way the questions were framed reflected a profound understanding from the media in New Jersey that the old system was flawed, the new system is flawed, but the new system is better than the old one. So by statute, there are statistics that must be kept under the new system, and the administrative director of the court, Judge Grant, who you saw in the first clip that we played, just issued his first report. And so what he found, was that in that first year, there were 142,000 people who were charged with crimes. So that's our universe, 142,000 people. Most of them were released on summonses. Almost 100,000 of them were given a summons, meaning told, come back to court on some date in the future. That was a dramatic increase from the year before. For those who were given warrants, meaning brought into this system that we've been discussing, 18% of them, 8,000 people, have been detained. Now, that's a lot. I will tell you that when I think back to Chief Justice Rehnquist's opinion in Salerno, where he talks about detention being the carefully limited exception, I'm not sure whether 18% counts. However, when you look at the full data, which is 8,000 people out of 142,000 people, what you see is that the actual detention rate is 5.6%. I want to see it get lower. That doesn't make me happy, but I will tell you that is a lot better than it was. And this is the statistic that really shocked me, because I didn't know how successful we would be in New Jersey at impacting culture change. Because I should say, New Jersey did not abolish money bail. What New Jersey said is, what we're going to do, and again, we talk about this in the other webinar, but first thing we're going to do is we're going to see, can we ROR the person? If we can't ROR her, let's see whether we can release her on non-monetary conditions. If none of those will achieve the purposes of the statute, then we can consider money bail. If that won't work, we can consider non-monetary conditions and money bail. And if none of that will work, that's when detention comes into play. And so we didn't know, kind of relegating money bail to third-class citizenship, how often would it be used? And the answer is 44 people out of 142,000 had money bail set in 2017. 44 people, all of whom got out of jail. So the number of people held on money bails in 2017 was 0.
So when we look at the system, and we've talked a lot about kind of the path that New Jersey went through to get to this place and to get to these numbers. We've also talked about how there's more reform necessary and that this isn't the end. This is a kind of a stop on the road, but it's a really good start. What strikes me is we can talk about the numbers, we can talk about the statute, we can talk about the changes that we made, we can talk about 142,663 people, but sometimes I think we need to hear the story of one person.
But before we do that, shouldn't we talk about what happened to the jail population? Do we have that slide?
Oh.
Do we not? Did I mess
yes,
that up?
we do.
Okay. So, in addition to these staggering changes, what it has meant is that just in 2017, there's a 20% decline in the number of people held in our jails pre-trial. As Jen said, we started this process really back in 2015, and since then it's been a 35% decline. Now, again, I don't think that's enough. I think we need to get more people out of jail. But, as Jen was alluding to, this is a really big deal. 20%, we're talking about thousands of people whose lives aren't ruined, whose jobs aren't lost, whose apartments aren't they're not evicted from their apartments, they don't lose custody of their children. And I think, as Jen said, sometimes with numbers this big, people become statistics. And I think we need to step back once in a while and remember what it means for one person. Which we will eventually do. So we're going to show you this video about one person's story. But before we do, let's just tease really quickly. As Jen said, this is a stop on the road. It's an important stop, and we don't want to see changes to our new system happen willy-nilly. We want them to be careful and deliberative and involve stakeholders as the other ones have. But I think we're going to need to look at the risk assessment, not because I have particular concerns with this tool, but because any tool needs to be constantly revisited to figure out whether it's working. And mostly, to my mind at least, what we need to test is it simply replicating? Obviously, we wouldn't tolerate a tool that increased racial disparities. Our statute, in fact, explicitly prohibits that. But what if it simply reinforces the disparities that exist in our system? New Jersey wears a badge of shame. Our prisons have the greatest black-white disparity in the country. Black people are 12 times more likely to be in a New Jersey prison than white people. That is disgusting, and we need to be taking steps at every stage in the process to address those disparities. We also need to make sure we don't become so comfortable with detention that what was a 5.6% detention rate becomes a 6.4, becomes an 8.2. I think we need to continue to mount constant pressure on the judiciary and on prosecutors and on defense attorneys to ensure that we really preserve detention as a carefully limited exception to the norm of liberty. Now I think we're going to get to show you the video we've been talking about.
Bail system in New Jersey was broken and it needed to be fixed.
The old system did not adequately protect public safety.
We need to have a system that doesn't treat people differently based on the size of their wallets.
Commercial money bail is one of the great injustices in this country.
My name's Tyler Hubbard. I'm 22 and we're at my Aunt Heather's house in Eatontown. The day after my graduation, I left to Pennsylvania to go to automotive technology school, and I had a job waiting for me when I got home. Being an automotive technician is a pretty good paying job. The longer you stay in it, the more you make. I have plenty of customers. I'm pretty busy. It works out pretty well. Basically what had happened, me and my mom's husband got into a big argument, and it ended up escalating in a way that it most definitely shouldn't have. That was basically my first time ever in the system. The charge was second-degree aggravated assault. I was mainly thinking, I hope I don't lose my job. I wouldn't have had anything when I got out.
Any time spent behind bars has serious consequences for that individual, for the family who relies on that individual, and more broadly, for the community.
They lose jobs, they lose housing, they lose connections to families and to communities.
And if you're not able to pay your child support, you're not able to pay tickets, it's very unlikely that you're going to be able to make bail.
My bail would have been upwards of $100,000, and I wouldn't really feel comfortable trying to gather that up from family members or friends.
Bail was set at $100,000 and you went to a bail bondsman, you might pay the bail bondsman $10,000. That is not money you get back.
When people can't pay back a bail bondsman, the bail bondsman coming after their assets, after their houses, if they can't pay it back.
This all really came to a head in 2013. The Drug Policy Alliance did this study. 40% of the people who were in county jails were there because they could not post monetary bail.
3/4 of the people who were being warehoused in jail were awaiting trial rather than serving a sentence. They stayed there for an average of 10 months.
Someone's whole life is derailed while they're sitting in jail pending trial.
People in the United States are so used to this commercial bail bond industry that they think it's normal.
Every country in the world has outlawed commercial money bail except for the United States and the Philippines.
It failed because it detained lots of poor people simply because they were poor. But the other problem was that there were rich people who were being released, even though they were dangerous, simply because they were rich.
No, I never had to pay bail. I would have been there a lot longer if things weren't how they are.
Our Chief Justice, Stuart Ratner, who put together his task force.
He called together what he called the Joint Committee on Criminal Justice. Judges, you had defense attorneys, you had civil libertarians, you had prosecutors, you had the Attorney General, you had members of the legislature, you had members of the governor's office.
There were some politicians kind of had to go toe-to-toe with them because some of them had differing opinions.
The goal of this committee was, let's pull together a blueprint for what became bail reform.
This was a piece of legislation that Senator Norcross and Senator Sweeney was trying to push.
And the governor had to call an emergency press conference where he came out and he was backed by urban mayors and people from across the spectrum who backed this measure, and he had to say to the legislators, get back in here and vote on this, and they did.
We have a ballot question in November that I'll be campaigning for and that I'm confident the people of New Jersey will support.
Here we had 2 Democratic senators and a Republican governor who said, I'm with that piece of legislation and I will sign it if you get it to my desk. It's too big, it's too hard, they have too much money. Well, all of those things were the case here in New Jersey, but we won. We won.
New Jersey is a couple steps ahead of the curve.
We're seeing already many, many more people who are not having to go to jail, keep being productive members of society while they wait for their day in court.
I think any state that has money bail should take a hard look at what we've done here in New Jersey. This is a positive example that other states can and should follow.
If you want to reform your state's criminal justice system, pretrial is a great place to start. These are people who are presumed innocent.
Since I'm not in jail, I can continue working, follow all my dreams, and I want to eventually have my own shop, build a pretty good clientele base.
Because we have numerous other organizations working together, like-minded folks, we can get some great things done.